What if I told you that your bareacts may be wrong? That is, some sections in your bareact may be wrongly printed, or some of them may be telling you that certain sections have been brought into force, but they are not yet brought into force by the state government or the central government, as the case may be. For example, this is a bareact from the Lawman's series, and it is the Industrial Disputes Act. If you read section 2J of this bareact, here it is provided that the definition for industry was amended in the year 1982 by Act 46 of 1982. This is a fairly longer definition that has been given for industry. But the funny part here is that 2J has not yet come into force. And unless you do a complete research, you will be following this particular 2J that is being shown to you by the bareact. The next bareact that we can refer for this is from the professionals. And even in this particular bareact, you can find that section 2J reads the same definition, which is the longer definition provided by Act 46 of 1982. Let us also check an online bareact just to make sure that 2J is in force or not. Now, this is the Industrial Disputes Act 1947 from the official central government site, which is for the Ministry of Labour and Employment. If you see the definition for industry here, which is under 2J, you will see that here also the longer definition has been given in the central government bareact. But here, if you see, the particular date from which this came into force has not been given, but the act has been given as Act 46 of 1982. If you check the Industrial Disputes Amendment Act of 1982, which is the Act 46 of 1982, Section 1 subsection 2 reads that Clause A, B and D to K will be coming into force from 21/8/1984. Whereas for the other clauses, the central government will be giving by notification any date, and different dates may be appointed for different provisions of the Amendment Act. But where does the definition for the term industry fall under this particular Amendment Act? If you see, Clause A is a different provision, Clause B is a different provision, Clause C provides for the definition of industry. So as you can read from section 1 subsection 2 and section 2 clause C, the central government must be appointing the date from when the industry definition change will be coming into force. But has the central government after 1982 appointed any date for this particular provision to come into force? For this, let us first look at this judgment from the Honorable Supreme Court, which will be a proper authority for us to make sure if the particular clause is come into force or not. The case is HR Adyanthaya vs Sandoz India Limited. The same has been reported in CDJ 1994 SC 1212. Now, if you read in this particular judgment, in certain paragraphs it has been observed that the amended definition of industry has not come into force. Remember, this judgment is from 1994. So, in the year 1994, the definition had not yet come into force. Likewise, if you read this judgment, Durgapur Casual Workers Union vs Food Corporation of India from the year 2014, pronounced by the Honorable Supreme Court, here also the old definition for industry was used by the Supreme Court. So it can be seen that even in the year 2014, this particular change was not brought into force by the central government. But what is the present scenario? How can we make sure that this particular change has come into force or not? For this, we can look at the Delhi government's site dealing with the Industrial Disputes Act. Here, if you see at the bottom of the page, it has been said that it is significant to notice that the central government, in exercise of the power conferred by Section 1, Subsection 2 of the Industrial Disputes Amendment Act of 1982, has not so far appointed any date for bringing the provisions of Sections 2, 7, 22 thereof into force. But as we have already seen, certain clauses of Section 2 have been brought into force, but Clause C of Section 2 has not yet been brought into force. I say that because there is no fixed date given on the bareacts or on the central government bareact that we found on their site. There is also this one other interesting bareact I found on the internet, which says that clause J shall stand substituted as follows when clause C of section 2 of the ID Amendment Act 1982 comes into force. So this shows that you have plenty of bareacts with plenty of footnotes and a variety of confusion that is out there just for one particular amendment in one particular provision. So how do you make sure that these bareacts are right or not? I have no idea, but I'm pretty sure most of us reading these bareacts right now are misinformed. And if we dig in more and if we try to do or find more errors in these bareacts, I'm sure we might be finding more of these errors, especially with these amendments and whether or not they have come into force. These are questions that can only be answered by a proper central government website or a state government website where all the amendments will be posted and all the bareacts will be updated so as to guide the litigants, guide the lawyers in the right direction. Now, if you can see, this actually misguides even people who are conducting any legal research, because if they are referring to the bareacts thinking these are better sources than referring to bareacts on the internet, then even in such a case, although they are spending a lot of money on the bareacts and they are getting these bareacts, they may still be misguided by these bareacts. And I think in a recent case from some high court, it was said that the publishers who are publishing these bareacts must be accountable if there are any errors found in these bareacts. I am in agreement with that view, because if we are spending some amount of money in getting a certain bareact, it means that we trust the service that is being provided, we trust the bareact that is being printed, we trust that it is up to date and all the contents therein are properly drafted. In law, obviously, as everybody knows, even a small comma can change the meaning of a provision. Is it right to leave bareact printing to private publishers? That is a big question, and certainly certain authorities must be responsible and answerable to all this. If you are aware of any other errors, please do share it in the comments box, and I hope we raise this question much more loudly so that we get proper response to this. And actually, I'm aware of 2 or 3 more errors, but I'm not posting them in this video. Maybe I'll make a second or third part to this video. If you found this information useful, do subscribe to Lawyers Society and do share this video, because this is an awareness video made for the legal community. I'm sure it will open a lot of eyes. Thank you.